8. 7. Okay.
Ready? Okay, good morning, ladies and gentlemen, fellow commissioners and staff. Sorry, I'm talking a little louder because of the noise from outside, but my name is Derek Yamane. I'm the chair of today's meeting. The commission may move into executive session to consider and evaluate personal information relating to individuals applying for licensure in accordance with Section 92-5A1 Hawaii Revised Statutes, and/or to consult with the commission's attorney on questions and issues pertaining to the commission's powers, duties, privileges, immunities, and liabilities in accordance with Section 92-5A4 Hawaii Revised Statutes. And again, like I mentioned before, I can see all of you who are here and present, but for taking roll, I do need you to answer. So I'm going to start off with Commissioner Abe.
Here.
Commissioner Andrews has an excused absence. Commissioner Emery.
Here.
Commissioner Goodell.
Here.
Commissioner Kyono.
Here.
Commissioner Acosta.
Here.
Commissioner Love.
Here.
And Commissioner Center also has an excused absence. Time now is 9:09 in the morning. We have quorum, the public was noticed, and I call this meeting to order. Starting off with the chair's report, just a quick mention. I did want to especially thank you commissioners for your service. I know Thanksgiving is next month, but I figured I'd catch it a little early. But I also wanted to really thank the traveling commissioners. Are you coming from the Big Island, Kauai, Maui on a monthly basis? It's not an easy thing. I couldn't do it, but you folks do it with a big smile on your face. I know how hard that is, so I just want to thank you folks for your service. Thank you very much. Moving on to Executive Officers Report, Miles.
The Commission shall afford all interested persons an opportunity to submit data, views, or arguments in writing on any agenda item, and shall provide all interested parties an opportunity to present oral testimony on any agenda item, subject to the conditions set forth in Section 16-99-83 Hawaii Administrative Rules. The Commission may remove any person or persons who willfully disrupt the meeting to prevent and compromise the conduct of that meeting in accordance with Section 92-3 Hawaii Revised Statutes. Item 3C. Oh, I'm sorry. Commissioners, we wanted to introduce a new member of our staff. He is taking over the position that was vacated by Joseph. So he's our new branch secretary.
Welcome aboard. Welcome.
Item is 3C, the minutes of the previous meeting, September 26, 2025.
The Commissioners had an opportunity to review the minutes. Does anyone have any changes that need to be made on those minutes of September 26, 2025?
Move to approve the minutes of September 26, 2025.
Thank you. It's been moved by Commissioner Acosta, seconded by Commissioner Kyono to approve the minutes dated September 26, 2025. Commissioners, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Not hearing or seeing any, motion passes. Thank you very much. Moving on to agenda item number 4, committees and program of work. We have 4A, Laws and Rules Review Committee. 4A1, the Regulated Industries Complaint Office, or RICO. request for an informal, non-binding interpretation regarding definitions of real estate broker and real estate salesperson with respect to Hawaii Revised Statutes 467-2, exceptions to licensing and required pursuant to Hawaii Revised Statutes 467-7. So all of you had an opportunity to review the law, the scenarios. Oh, okay. And I believe the attorney is in the audience. Hello, Mr. Galindo. Yeah, you can address us or answer questions, whichever you choose.
Thank you, Mr. Commissioner. I would be pleased to answer any questions that the commissioners may have regarding the request. If I don't speak loud enough, forgive me. I sometimes have trouble competing with noise from outside.
No problem. Thank you very much for being here to answer questions. It looks like,
I just,
Oh.
could you please identify yourself?
Yes, Paul Galindo, staff attorney with the Regulated Industries Complaints Office.
Commissioners, do you have any questions for Mr. Galindo? Commissioner Acosta, go ahead.
Thank you, Chair. In the definition, and obviously I'm not one of the wonderful attorneys in the room, it talks about, the definition has, talks about secures, receives, takes, or accepts and sells or offers to sell any option on real estate.
Yes,
And
madam.
I found that word interesting because usually option means you can take it or leave it versus an actual contract to buy. I just wondered why that word was in there, please.
I don't know, because that's the definition that the legislature has enacted. What we have laid out in the scenarios is what we suspect at RICO may be an analogous situation. Whether it qualifies as an option, I think may be up to some discussion. I don't have my copy of Black's Law Dictionary in front of me right now. My understanding of an option is that it is a contract that allows the holder of the option to acquire property or something of value for a stated price. And in that case, it is analogous or not inconsistent with a real estate contract. Naturally, of course, that a real estate contract, if it becomes breached, has some consequences that attend to it that an option may not have. But we question whether the situation is sufficiently analogous to qualify as an option. But as to why the legislature used the word option rather than also alternatively the word contract, I can only say so. That is what the legislature did in its wisdom.
Go ahead.
Mr. Galindo, to your knowledge, has RICO handled any other circumstances that are similar to the fact patterns in scenario 1 or 2?
Thank you, Mr. Commissioner. I would love to be able to address that more squarely. The people with the corner offices who wear nicer shoes than I do and have better parking spots forbid me from discussing too deeply. So I can neither confirm nor deny. What I would say is that RICO is aware that there are circumstances and conduct and transactions in the community that are comparable to the ones described in the request for informal interpretation. Just taking me, for example, and this is not necessarily the subject of any investigation, either past or present. I've driven around the city and county of Honolulu and noticed on telephone signs or telephone poles signs that say, "We will buy your property, cash." And now that we are in the day and age of HGTV, Property Brothers, and the popularization of purchasing aging homes, improving them and flipping for value, it is not too difficult to imagine a situation where someone who purports to purchase property for their own account and improve and sell may on occasion acquire the rights to purchase property and then midstream before completing the transaction sell the rights to acquire that property to someone else. And so while I can neither confirm nor deny that RICO has in fact encountered those situations, it is our hope that the Commission's informal, non-binding interpretation may help to guide our decisions as to whether or not these things or circumstances are worth investigating.
So nothing has come to a decision before related to similar to these facts?
To my knowledge, we haven't encountered these specific facts before. But again, I can neither confirm nor deny.
Well, you should be able to if the decision was rendered, right? Because that's public. You're saying for things that may have been investigated and didn't move forward, you're not able to speak to them.
That is correct. But as to a commission's final order, no.
Yeah.
Thank you. I misunderstood your question, Mr. Commissioner.
One more question.
Yeah, go ahead.
What about situations, because I see the different scenarios. Scenario one, it's really just an isolated transaction. Scenario two, there's multiple. How does RICO typically handle, or how have you handled in the past other situations where it seemed like it was a one-off situation?
I can neither confirm nor deny. One-off situation, it may come down to points in investigation and disagreements or questions as to whether or not there is factual sufficiency or legal sufficiency in order to pursue a complaint or to pursue an investigation. In a limited set of facts and without more than an isolated incident, it's hard for anyone, and I think reasonable minds within this room can disagree or agree. People can have a discussion as to whether or not an isolated instance of conduct rises to the level of the definition that rises to the level that meets the definition as defined within the statute. And while some people in my office may say on the one hand it does or it does not, I can imagine a situation where the investigators or the attorneys reviewing the case might feel comfortable enough that we don't have enough information or enough facts to be able to support a plausible, non-frivolous legal argument that the conduct does rise to that level. And so may, in that case, issue a warning or may close the case for insufficiency of evidence. So while I cannot say definitively and neither confirm nor deny, I can imagine that those might be the scenarios that would run through someone at RICO evaluating that type of case.
And would you say that that's also trying to discern based on the facts as you can ascertain the intent of the party is taken into consideration?
Yes, and because intent of the parties, without having a clear pattern of conduct, it is difficult, other than what is stated in documents or memoranda, what the parties are. If the parties are playing it, I would say, cute or carefully, they may not say very much in memoranda or discussions or papers in an isolated transaction. However, even if that sort of carefulness and caution continues over time as laid out in scenario number 2, if a transaction repeats itself sufficient number of times with sufficient dollar signs attached to it, it begins to look less and less like an isolated instance and more like intentional conduct.
Yeah, I see that the statute does have the language for the purpose or as a means of evading, and so I would assume that that's what that means. In order to meet that portion of the statute, that's what you're looking for.
That's what we would be looking for. And again, it's not to say that in an isolated instance we could not determine that if there is sufficient indicia of it in stated memoranda or overheard in discussions. But in the absence of that, how does one determine or how does one find and conclude that there is, for lack of a better expression, mens rea or state of mind And I think it would have to be through the repetition of conduct through a pattern of transactions that reveal that over time.
Thank you.
Commissioner Emery.
Did the entity, or maybe the assignee, in that process of acquiring the option, use a licensed real estate agent in that transaction to acquire the option?
No,
Sorry?
no.
Okay, thank you.
Just a thought. Do you consider, especially in scenario 2, that they could be advertising or marketing to continue to do this? Is that a factor? Because how do they do it so many times, and unless they're soliciting somehow? You know, I'm thinking, is that a factor? Or is that a...
I can't say that it's a factor, a known factor in the scenario that I put out here, but I think it's certainly something that a finder of fact would consider in assessing whether or not the conduct rises from simply an isolated instance, or rather innocent handful of instances to something that is intentional. I think the more outward and the more public the displays are, such as advertising, I think would tend to pull closer toward using the pattern of transactions as a means or a purpose of avoiding licensure requirements. But I can also imagine a situation where the absence of that would also qualify. Say, for example, that we have two parties, and this is not necessarily the fact of this case, but say that we have two parties who have an established relationship with one another and know that the same assignee can reliably go to the same entity repeatedly because the entity engages or is known to the assignee to engage in these types of transactions, and is either agnostic or would prefer not to complete the purchase, improvement, and flip. So it could go either way. But I think certainly to Madam Commissioner's question, advertising, public announcements, or reputation in the community would certainly be something that would be considered. And I think is important in making that determination.
Commissioners?
Assignee could be like a LLC or a group of, local type Huawei too. Do you see that too? So it could be like several, like a lot of people in this entity, like a LLC or...
It could be. And the assignee does, I have it set out in the facts of these two scenarios here, that the assignee is a limited liability company in Hawaii. But for these purposes, or I think for the purposes of the law, the assignee could easily be a natural individual person. The assignee could be a corporation, a company, a limited company, or even a limited partnership. What I wanted, and I just happened to pick these facts out, what I wanted to impress with the fact that both the entity and the assignee are limited liability companies is that for the purposes of the owner exception, maybe trending toward that there's no common ownership between the two. So it could not be said that the assignee purchasing the assignment of rights is in fact the same person who is holding the rights to purchase it in the first instance. I think it would be perhaps a closer argument to say that there is no exchange of assignments purely on paper, perhaps, if there were common ownership, if there were common control. I think that would be, in order to clear the hurdle, or in order to clear the exception, to meet the exception, I think that set of circumstances would more closely align with the exception. However, I put in the facts that there's nothing in common, no managers, no members, no ownership, to make that clear for the purposes of the exception. But thank you for your question.
Commissioner Goodell?
Just to comment on your Commissioner Abe's thing on how do they advertise. One of the ways they keep themselves off the record is they're doing direct. Very often, I've found that they're doing direct marketing, email letters to the area owners of various properties and soliciting a sale. Where that conversation goes, who knows? Yeah. And but I would suspect, and I've seen it on the side where it ends up either into contingent contract that's so contingent it has nothing down that it might as well be an option, or an actual structured as an option agreement. And then they go out and shop the property out to other buyers that they may have. And typically I find it on land transactions. Big time on the Big Island.
Commissioner Acosta?
Thank you, Chair. So if the intent is initially to put this property under contract, but option it, sell it to someone else just to get a fee, is that still a real estate transaction, or is that a securities transaction?
I don't know, I don't practice in securities law. But since we're here in a real estate matter, I would say, and pull very hard toward it being a real estate transaction that perhaps has indicia or perhaps has features as well of a securities transaction. But again, I think I will defer to my colleagues in securities enforcement about that one. But I think just as someone who doesn't practice in that area, I think the more multiplicious that conduct is, I can find a stronger argument that it trends toward that as well. There could be very many interested parties in that.
Any other commissioners have any other questions? Or do you need to take it under advisement or have an answer, Mr. Olelo?
We have the ability to discuss this in executive session. I would move to refer this to an executive session.
Second.
It's been moved by Commissioner Emery, seconded by Commissioner Acosta to take this matter into executive session for further discussion. Commissioners, all those in favor say aye.
Aye.
Any opposed? Not seeing or hearing any, motion passes. Thank you, Mr. Olelo.
Do the commissioners wish for me to stay around, or is that all for now?
You're a busy man. You got a lot of things to do.
That's a very generous statement.
Staff will get back to you. Staff will get back to you on it.
Thank you, Mr. Chairman. Thank you, commissioners. Thank you for your time.
Right now, or just, you can do it later. Okay, do it later. Okay, so put this on the side. We'll just move on to next item on your agenda, which is now 4B1, rulemaking for the rulemaking, chapters 107, 119, status update on the commission's proposed condominium rules, simultaneous repeal of Hawaii administrative rules, chapter 16-107 relating to horizontal property regimes, and adoption of chapters 16-119.1 through 16-119.8 relating to condominiums. And this one, I am going to just ask, still under review. Thank you very much. Still under review.
What is it under review? By which entity?
Attorney General's office.
My department. I'm
An
still
estimate of when this theoretically might be completed?
I hope before the end of the year.
Thank you.
Thank you. Moving on to the next item, 4B2. We have case law review. Starting off with A, Ridley versus Rancho Palma Grande Homeowners Association. I believe staff is just going to make a quick comment on this case, or you want me to put the two together?
I can go one by one. Good morning, Commissioners. The first case the Rancho Palma Grande Homeowners Association. Brief summary, the plaintiffs owned a condo unit in a Santa Clara complex managed by an HOA. April 2018, there was a flood that occurred in the crawl space beneath their unit, which is a common area under the HOA's control. The initial investigation suggested that the water originated from an undestroyed well, but the HOA delayed repairs for over 19 months, during which the unit sustained damages that included mold and a termite infestation. HOA repeatedly ignored experts' recommendations and ultimately failed to properly investigate or remediate the source of the water and damages. Plaintiffs filed suit against the HOA and its president, alleging breach of the CCNRs, negligence, nuisance, and other claims. And after trial, the court found in favor of the plaintiffs on all claims, awarded damages for restoration, lost rent, emotional distress, and also issued an injunction requiring the HOA to complete the repairs and compensate the plaintiffs until the work was finished, and further found that the HOA's conduct was grossly negligent and awarded their damages. Upon appeal, the appellate court affirmed the trial court's findings, holding that there was substantial evidence that supported the trial court's findings, and also concluded that the HOA's conduct constituted gross negligence. So just an FYI.
Thank you very much. So just to refresh, it's for a appellate court case in California. But Commissioners, do you have any questions for staff or any comments? If not, we'll move to the next case. Thank you very much, staff. Moving on to the next case, which is 4B2B. Even versus certified management. So this is a Hawaii case.
Yes.
Staff, can you brief us on this too?
With the Supreme Court, just to make it short, the plaintiff was charged like $1,400-ish for document packages connected to the sale of his unit. Certified management, as the association's managing agent, delivered the documents through an online portal and imposed processing, convenience, expediting and transfer fees, and taxes. Essentially, the Supreme Court concluded that certain resale-specific documents, two in particular, the Hawaii Association of Realtors Form RR-105C and the Statement of Account, are information and disclosures related to the resale of units and are thus covered under the Condominium Document Request section in HRS section 514B-154.5. And as certified, maintain an online community archives portal to deliver these documents. Certified was required to provide these resale-specific documents at no cost, pursuant to 514B-154.5, subsection E. I hope I summarized that brief enough. Available for any questions.
Thank you.
I'm able to answer them.
Commissioners, anyone have any questions for staff, any comments, discussion on the case? Commissioner Acosta?
Thank you, Chair. So if I were to have a condominium and request those documents, I go to their portal, I upload them, and there is no cost, correct? According to this?
Essentially, yes.
This, okay. What are the safeguards to be sure that what is on the portal is correct and updated timely? Anything?
I'm not sure. Nothing in the condominium law.
Okay. I'm just wondering how much do you rely upon that, and then what comes back to you if it's not correct, so, okay, thank you.
My past experience, some of my past experience on the RR-104C 105C, is that many associations will not provide those outright and will not fill out those. I don't know how true that is in Honolulu, but definitely over in the Big Island, we've had problems because it's so individual and time-consuming for them to fill one out for each of the sales. So many times they don't go with a sale. In many people's view, it's still the owner's responsibility to disclose it, even if the association isn't going to fill out all that document. It's still, as the contract, they're obligated to disclose everything that they know. So I'm not sure whether that gets to your question or not.
No, sorry, Jim. My question was about the information that is provided on the website, in the portal, by each condominium association. And if you depend upon that to give to your buyers or your sellers, and it is incorrect, then where is the liability, number one? And number two, if sellers are required to have a seller's disclosure, why are condominiums not required to do their own disclosure irrespective of what it takes? Because by not disclosing everything, a lot of times there are things decided in executive session that the general population, the owners, don't know. So I'm just wondering why the R105C is not mandatory for each sale as seller's disclosures are.
Association attorney. Commissioner.
Yeah, no, good questions. I think it's a little bit off the track of, basically, this is just a case that has been decided upon. Staff is sharing it with us. Those are very good points, very good questions that I don't think staff has ability to answer. So if you folks can find out the
The
answer.
industry, I can tell you, they don't have an answer either, because the actual practice and circumstances vary so much, because this particular order applies to sellers and sellers' agents, but not to buyers and buyers' agents or escrow companies or mortgage companies or lenders. So it's a state that's under great discussion within the industry and how they're going to approach this.
And just one last comment. The form itself that the HAR has produced, having been party to some of the generations of those forms, was primarily or one of the big users of that is the lender. And it's something that the lender needs to know. They need to know what the numbers of vacation rentals are and those types of things. So much of the questions are structured not to what the buyer may want to know, but what the lender wants to know, and it's usually consolidated information. And the lender then has to go back in, because it's a consolidated form, and every lender has a different set of questions they want. They go back in and ask even more questions. So in practicality, that's how that form is sort of generated and used in a lot of cases. It isn't just the seller, buyer.
original committee that formed the RR105C as an industry representative. And what people don't seem to realize is that under Section M of the purchase contract, seller agrees to provide certain documents. And that's what we're talking about here, that portal will give them those documents. But the lender of the buyer typically will not accept those documents from the seller. They go in on their own because they want an independent, hands-free set of documents to validate that issue, for example. So this has created an issue because the treatment of a seller and their agent is going to be different than the buyer and his lender and their agents. And because realtors are typically under time frame stress to get all these documents completed, most management companies contract with the association, do not provide for them to have to do this resale documents. So it's going to be an issue that the industry needs to address to comply with the court order, but I don't have an answer with the final answer. I've heard a lot of discussions on potential answers, but I don't think it's been resolved yet. But we just need to be aware it's out there and it is going to be controversial.
Yeah, I would agree.
Yep, I think you're absolutely correct. It's just we need to be aware this is what it is, but it will raise a lot of questions, issues, and concerns that we don't have the answers to just yet. So thank you very much, staff. Thank you very much, Commissioner. Moving on to the next item on our agenda, 4B3, Condo Governance and Management, 3A, excuse me. This is for ad hoc committee on condominium affairs and solutions, report of October 7, 2025 meeting. They have a request for a change to the committee name, and I'm going to ask staff to brief us on this before we make any motions. Tina, go ahead.
Great, thank you, Chair. Yep, this is twofold. One is a report, and I'll give a, hopefully it's brief, summary of the discussion of the meeting, and their request to change the name of the ad hoc committee. Meeting was held via Zoom. After welcoming members, I kind of outlined the ad hoc committee's purpose, which is supporting the commission, exploring various condominium issues, their complexities, and maybe identifying some potential solutions. Discussion started on recent legislative measures such as Act 96, which is the insurance crisis bill with the HRO, CIA, and the condo loan program. The Act 43, not this section, last section, which is the LRE study on condominium regulation done by other states and the pros and cons. The findings of those study are expected to be received by LRE prior to the upcoming legislative session, including discussion on the legislative resolutions, such as the oversight, possible licensure of condominium association managers or similar titles. The ad hoc committee members highlighted challenges with keeping managing agents up to date of the new laws and the ramifications of mandatory licensure or board member educational requirements. For example, could mandatory licensure for the employees of the managing agent, because there may be an argument that they have to meet, but the standard is higher, that they argue for higher pay. The money would likely come from the association contracts, which probably get passed down to the unit owners through higher maintenance fees, that sort of stuff. And the employment through managing agents is already kind of a revolving door, so it might exacerbate the shortage of the employees for managing agents. And potential quorum issues for board members if they were required to have a mandatory educational requirement. A couple sessions ago, there was a bill that proposed to require mandatory education for board members, and I did receive a phone call from a board member that indicated that, well, she asked for the status of the bill because she had planned to step down as a board member if the bill had passed, but the bill didn't pass. But I guess in some way that's kind of evidence that it may cause some quorum issues for boards which may already be experiencing some quorum issues with their associations and boards. Further discussion, it started getting a little bit more fruitful. It was kind of surprising, regarding deferred maintenance and reserve funding plans and practices. There were some ideas on requiring to include and fund repairs that's recommended by a real estate repairer in their funding plan, and establishing a fund that's restricted solely to fund that one component with deferred maintenance, starting immediate amortization, and this, not really a blanket, but because condominium funding plans are for 30 years, they said, well, maybe this idea could apply for condominiums that were built over 30 years ago. Would make it pre-1995. But members agree that these ideas would merit some further exploration. The Supreme Court case that was just discussed was also brought up. And a member mentioned that legislation might be anticipated in response to the case. All in all, though, I think it'll just be waiting for the results and findings of the LRB study and to see what findings and maybe proposed legislation comes about if LRB will be drafting legislation with those findings. And then prior to adjournment, members requested if they could rename the ad hoc committee to the committee identifying vital issues in condominiums, civic, noting that the acronym kind of aligns with its objectives, collaborating with subject matter experts, assisting the commission's engagement with the condominium community, and is more memorable than abbreviation like ACAS. Available for any questions, and again, that's the ad hoc committee's request. They will still remain an ad hoc committee. There's no expansion of anything, no changes to their objectives.
Thank you very much, Keaton. So basically, you folks have been busy. You gave us a summary of what's been transpired from your last meeting, and you just want to change the name from ad hoc to civic.
I don't think there was an abbreviation. I think it was abbreviating into, like ACAS.
So they just want to be known as a civic.
Yes.
Staff has no problems with that as far as.
Yes.
Nothing changes. Still same people, same agenda, intent and. Commissioners, do you have any questions?
I would just make one comment. We have a tendency in the real estate industry, we mentioned the word condo, to think of residential condos usually larger in size. When you look at the number of condos in the state of Hawaii today, there's about 1,700 condos. Of them, 850, approximately half, have less than 50 units. Of those 850, 425, about half of them, are less than 20 units in size. So then you start looking at, we have parking condos, commercial condos, agricultural condos, senior living condos, assisted living condos, but we have one law, 514B. So when we look at these issues, we need to be able to realize that the effects of this report may impact, for example, a 3-unit condo having to have mandatory education. What is that going to do in the real world about trying to impose it? There's got to be some consideration to the vast size and scope and differences. Because of the 1,700 condos, about 50% of them are over 50 years of age, for example. So the reserve laws and things like that would be more effective with regard, theoretically, to them than a brand-new condo in Kaka'ako, although I see all those problems even there. So anyway, I just think we had to realize in the scope of this committee, it's got to be eventually put into a perspective of what the industry encompasses and is as a total, because one size does not fit all in the answer.
Excellent point, Chairman.
Yeah, I totally agree with that, Richard. And going into this report, it says association managers. I think it's really important to distinguish because there's property managers that are licensed, professional management companies are usually licensed, and then there's resident managers, site managers, et cetera. So really important to distinguish that. And then smaller, like you said, less than 50, they may just have a site manager mostly. So I think it's really important to distinguish that type of manager and then also the size of the project, because different size projects will focus on different kinds of management situations because of the cost, effectiveness of their cost. And just one more thing, is kind of off the subject, but kind of, because I noticed that when I sit on these board meetings, A lot of them are asking a lot of questions, like Vertical was at one of these meetings recently, and is there like a tutorial online that can be done, just really basic how a reserve study works? Because they were asking really simple questions, just really basic, you know? And I think it will really help them, because now they're getting all these independent reserve studies and they have no idea what it means. So I was thinking, you know, they can go online easily, just even owners, not just board members, but something kind of basic like that, maybe something to think about.
I think that's a good idea.
Yeah, I think so.
Because the other thing I would just mention about condos as whole, 80% of them approximately have managing agents. 20% are self-managed, they don't have a managing agent. And of those 80%, the scope of work of their contract varies differently. So a very large association, typically the managing agent contract is very nominal, usually collecting the maintenance fees, paying the bills, and doing a financial statement. The smaller the association gets, you get into administrative help on board meetings and minutes and annual meetings. So people have a tendency to think everybody has a managing agent, a professional management company, which is not true. Only 80% do. And those contracts vary dramatically between a full managed project versus a financial-only project. So again, in the language that comes forward, we've got to recognize that exist in the industry. But I think you're correct, because as a volunteer in the industry, lecture all the time on reserve studies and the history and the options and how to comply. And most people don't understand the complexities of it. And so I think anything we can do to provide another resource would be good.
Good point. Right. The public is lucky to have you folks, because you folks have wide knowledge and you have expertise that you look at everything from all sides, and so the public is very well prepared. Any other comments for staff? Or any questions, commissioners? We need a motion to change the name. That's what, yeah, so if unless somebody disagrees with that.
I move to change the name from the ad hoc committee to Civic pursuant to the request.
Second.
It's been moved by Commissioner Acosta, seconded by Commissioner Kyono to change the name or establish the name of Civic for this group. Commissioners, all those in favor say aye. Aye. Any opposed? Any abstentions? Not hearing or seeing any, motion passes. Thank you, staff, for your hard work. Next on the agenda for D4, owner occupant Chu, request for exemption of owner occupant requirement pursuant to HRS 514B-98.5B4. I do believe there is someone in our staff will address it first, and then there's also someone in the audience who's going to discuss this or answer questions for you, but go ahead, staff.
Brief synopsis, we have a applicant for owner occupancy exemption. While the staff does have delegation to decide these, we do follow a precedent that the commissioners have set over many, many years. This is the first one I've ever seen where it was revolving around remote work where the job itself didn't move. And since we literally have no precedent in any way, shape, or form on this, we decided it was best to bring it to the commission to determine future precedent or actions. Essentially revolves around a buyer wanting to remote work employee, but her employer requiring, changing the remote work to require partial in office. I believe the agent for the applicant is in the audience, who should be free to answer any of your questions, if you have none for me.
Commissioners, do you have any questions for Dayton? Yes, go ahead.
Just one quick question, David. I know you said there is no precedent, but is that with respect to return to work, or do we have any precedent for the unforeseeable job?
No, for the remote work.
So what is the precedent for unforeseeable job?
That usually is a actual transfer of your job, where your job has been moved, you've been deployed to another location. Usually we get these military ones where
Yeah.
they're short notice and they gotta go.
Anything outside the military context? that you
We
recall?
have some where they got a job somewhere else. They were planning to work here, but then they got a job on the mainland and they gotta move. And usually that one, they'll sell it or they get out of the whole contract. And then
I was gonna ask you, so what do they do if the exemption is granted? They still have to buy the unit?
I think in those cases, usually they'll buy it and they'll rent it, or they'll buy it and then they'll sell it. And then they'll basically get out of the contract one way or another. Sometimes they can avoid this by just having the developer swap
Yeah,
it
I
for
think
another
this
one.
developer
But
doesn't do that.
Some don't have a backup list, some
Yeah.
don't want to do it. It's up to the developer at that point. But this one, we never had a remote work question come in. And I suppose it is relatively novel, and we probably won't get one again. But yes, given the fact that there's lack of precedent, decided to have you commissioners probably take this one.
Okay.
Sorry to bring this case up.
Hi, Patty. I need to disclose that I do know Patty. She does work for locations where I work, so I just need to make that disclosure. But I can remain fair and honest and make a fair and honest decision on this matter. But introduce yourself, and you got time to explain the situation to the commissioner.
My name is Patty Papayama, and I'm with Locations. And have been a partner, but now I'm an emeritus partner. And I am coming before you because I have never had this happen to me before either. So this person, she's single, she works for Google. And at that time during COVID-19, they gave her a mandatory thing where you must work remotely. Must work remotely, you're off on your own, we close. And she's always wanted to live in Hawaii and said, okay, you know, I'm gonna work remotely from Hawaii. However, she fell in love with Ward Village. And the problem was the property she fell in love with was not yet built. So she signed the owner-occupant affidavit, so eager to get the unit. And after several years, Google opened up and it became partially mandatory that you be in the office so many days of the week, but you can work remotely these other days of the week. And then as the years went by, they became more strict and kind of like enforced a rule that you all have to work in the office except for these who had exemptions. At one point, Penny was in the state where she could have gotten an exemption. However, those have filled up, so she doesn't have an exemption at this point in time. And the reason why we're asking for this now is because Ward Village has time frames where you have to get certain things done. And one of the things that's coming up next due in November is her loan application. So she can actually pay cash or do loan. However, she would prefer to do a loan. And in doing the loan, she's an owner-occupant. Wanting to be an owner-occupant, you're required to live in there for 365 consecutive days out of the year. Conflict. I have to now work in my office. So she cannot do that at this point in time. So we have that situation there. Talked with Ward Village and they said, it's out of our hands. We understand the situation. It is what it is. During that time frame, that's what happened at that point in time. Take it to the commission and let the commission decide if she can change her owner occupancy to a second home buyer. In other words, this is going to be her residence while she's here. She's still going to reside in it, but she just won't be able to reside 365 consecutive days. She will be able to reside when she can, when she's allowed to. And in hopes, you know, she wants to keep this forever. So I'm letting you folks guide us, because we really don't know what to do to get a loan, she has to change the documents to say second home, or she can't get the loan. But on the second, another portion there, she can get cash, but, still, she's not falling into, I'm gonna knock on your door and make sure you're there 365 days of the year. And she wants to be legal. She wants to do things properly. So that's why we're bringing this to you. If we can change it to a second residence, we would really appreciate it. As a second home, her second home would be here in Hawaii.
Thank you. Commissioners, you have any question? Commissioner Goodell.
Is there the reason that, which piece of work is prohibiting her from, is it the lender basically that's prohibiting this? Or is it the owner, or is it a state law?
Okay, so when the developer offers a new project for sale, they offer 50% to anybody who can be an owner-occupant or a investor or a whatever they want to be.
Which is pursuant to a state law.
Correct. But they are required then to offer 50% to owner-occupants only for a certain period of time. She was here in Hawaii shopping during that owner-occupant phase, but she had no problem because her intent was to be an owner-occupant and move to Hawaii. And it all went fine until Google decided, we want you back in the office. They felt there was more synergy. They didn't want them to work.
So the intent was that when it was sold, at that time, she was an owner-occupant pursuant to the agreement that for the developer to meet that particular thing. So there's no, I'm not sure I see a problem there at all, because she did that, and it's no different than a military person being reassigned to somebody else. They had an intent, they fulfilled that intent, but the regulations that keep her from, or that would force her to sell or to give something back or to, those are usually covered in the agreement.
It's called an owner-occupant affidavit.
Correct.
Is what she signed. So, but in that, it is very clear that you need to be there 365 consecutive days of the year. And she does not want to break any rule, any law. She wants to be a good citizen of Hawaii, pay the taxes that she needs to pay. She wants to live here. Unfortunately, she cannot do it right now. The property will be closing in June of 2026. So you see, when she signed it back in 2021, her situation with Google was different. It took this many years to close, which we knew it was going to take time to close. We had no idea that her opportunity to work remotely would be revoked. So that's the issue that we have.
So quick question. So she's going to buy and close it. She's not trying to get out of the contract with Castle.
She wants to eventually reside here. She wants to live in Hawaii.
So in the development, is it totally sold out?
There may be a few units here and there. You know, they usually have little stragglers left after closing, but not much. I really don't know the percentage, but I feel like it's at least 80% to more that's already sold. People are waiting to do the final inspections.
Commissioner Acosta?
Thank you. The unit that Ms. Chu bought was owner-occupant. So, and I noticed it was on the 28th floor. So are there specific units, when you were asked by Neil about are there any other units, would that preclude her from buying this particular unit if it were not owner-occupied?
Would that preclude her? She may not have had that particular unit at that particular time, but it may not have precluded her from buying something else because her goal is to reside in Hawaii.
But if this, just for sake of argument, if this is denied, then she will not be able to buy this unit? Is that correct? And she has to buy something else, or?
She would probably be able to buy it because like I said, she has cash to close it. What she doesn't want to do is break any law. She doesn't want to, the whole feeling is gonna be real, won't be as exciting and in love. You know you're doing something wrong, you don't feel good about it. I signed a paper that said I'm gonna live there 365 days. Patty, what am I gonna do? You know, I had to go for the loan, the lender reminded me, blah, 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 blah. You signed an owner occupant affidavit, but you're working for Google, how are you gonna do it? Called me, what are we gonna do? Called Ward Village, call the commission, and try to see if you can get that ruling change to a second home purchaser. They will be fine with it if the commission is fine with it.
I have a question, couple of questions now. So she's still living here, or she's?
She's in California, she was.
Okay. And next question is, if she was to pull out, will she get all her refund back?
Definitely not. Ward Village does not
No
do that.
If I heard you correctly, though, she's not trying to get out. She's still gonna buy it. What she wants to do is go from owner occupant, which requires 360-day occupancy, to second home.
Yes.
Is there a definition for second home that they give?
Not that I
It's not in
know. In other words, she can come here on her vacation, she can come with her family, she can, it's her home.
Can she sell it in that 1 year, though, if it's a second home designation?
Probably not. She's not planning to sell it. This is.
But she could sell it.
Well, that's a question that I guess, I don't want us to change it and then give her that free rein to make profit.
So was it a market rate, the purchase price?
No.
It was below
Oh,
market.
no, it was a market rate.
Was market rate.
But I'm sure that she would be happy to sign anything that the commission wanted her to sign, to say, I will not sell my property, because she has no intention of selling or renting. She would just have to keep that vacant to comply with that owner occupancy, 365 days, no rental income, no timeshare, no nothing. This is my home. I don't want anybody in it. I want to follow the rules. However, it's going to be my second home. I can't be there 365 days of the year.
So if I heard you correctly, if we look at the agreement she signed with the developer, yes, under paragraph 1, it says, it is our intent to reserve the purchase, blah, 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 for 365 days.
Yeah.
And then if you go to the last paragraph, paragraph 10, any false statements of this is a violation, and it's a misdemeanor, it could be a civil penalty up to $10,000 or 50%. So she's trying to avoid that last paragraph where she's a bad person.
Yeah, exactly. Yeah.
That's what you're trying to say.
Yeah.
I just want to make sure that's, and I understand what Commissioner Acosta said, like, was she, because she was an owner, did she get a preferential treatment of choosing a better unit? And then what other commissioners are saying, if it's a second home and there's nothing in the laws that says it, can she resell it prior to 365 days? So all very good points, but is there any other questions for her?
I would just comment that at the time she entered into the purchase contract and signed the affidavit of owner occupant, that was all true and honest at the time the document was signed. And we all know we had COVID and laws changed, things changed. And it's just one of these oddball things that happens that wasn't considered when all these rules and laws were written. So I don't really have an objection to, in principle, to the request.
I'm just wondering what kind of precedents it will set, though, because, there's a high demand for owner occupancy in Hawaii, high. And I know because people wait, and sometimes they don't get it. And it's very frustrating. They try for years. And so I'm thinking about what precedents, a second home, and then it opens it up for whoever, investors. And that's my concern, really, because I feel like I'm out in the trenches with these people who want owner occupant and they can't get it. So that's my concern.
Yes, I think it's a very good discussion, very good points from the people. And Patty, just so you know, very intellectual, reasonable people on this commission, but I think it's something that they probably want to take under advisement. If I see their faces, I can already, I've been doing this long enough, I can see half one way, half the other. So instead of us rushing and just making a rash decision, I'm gonna make a motion to take this under advisement. If I can get a second, we will discuss it and staff will get back to you. But, so it's been moved by Chair Yamane, seconded by Commissioner Emery to take this matter under advisement. Commissioners, all those in favor say aye. Aye. Any opposed? Any abstentions? Not hearing or seeing any, motion passes. So we'll get back to you, but thank you for coming.
Thank you, everybody, for your time.
Thank you. Now we are on item 4B5, condominium education outreach. There's a condo-rama. I'm gonna just have staff quickly address you folks, and Dayton's gonna tell you how successful this program has been. Go ahead.
So we are doing another Conorama. As you can see from the flyer, the topics. This one again will also be online. It's unlikely we are going to go back in person, as our attendance went from a high of 200 to a high of 1,200 once we went online. So for the foreseeable future, it's going to be online seminar. It also allows people to watch it whenever they want after it happened. It is entirely free. It has been publicized out to our subscription list and to all the associations by a paper mailing of the flyer you have in front of you. Do you have any questions on the upcoming seminar? As you can see, we've had many of these, and we hopefully will have more.
Commissioners, do you have any questions for staff or any comments other than keep up the good work? I appreciate it. The public appreciates you educating them, so thank you very much. Next item on the agenda, we are now moving on to 4C, Education Review Committee, 4C1, pre-licensing, 4C1A. There's a request for quotes, RFQ, to update and amend the Hawaii Real Estate Broker Pre-License Curriculum. And you have in front of you that RFQ. We do need a motion for this, unless you have any questions or concerns for staff. Go ahead.
Thank you. Thanks for putting this together for us. Why do you think there's such a huge disparity one to the other?
I'm not sure, Commissioner. This is the first time the higher bidder bid on one of our RFQs or any one of my RFQs. I'm not sure why such a big disparity.
Comes in independently, so it's not like they know what, but that's a good question.
Yeah, I'm not familiar with other company, but I do know Scott Bly, excellent. He is so knowledgeable and a great teacher. With my experience with him, I don't know the other company. He's very reasonable, his offer, for his level of expertise, I feel. He does, I know he does a lot of real estate in his practice to conveyancing and legal description and stuff like that. So, so anyway, I think it's very reasonable.
I just want to go on record that I have taught CE classes at Bly School of Real Estate, but I feel I can make an independent judgment with regard to this matter.
Commissioner Acosta?
Thank you. Who is AJAWA? AJAW LLC? Are they from Hawaii? From the mainland?
No, they're not a Hawaii company. Again, this is the first time I've seen him or this entity bid on anything, on any one of my requests for quotes, but not a Hawaii company.
I did Google it. There wasn't much about it, but it looks like it's on the mainland. But I couldn't find much information on them.
Did they submit anything in support of their bid, or
Support,
why would they, what are they going to accomplish for the bid price, or were there any notations on the bid that set them apart or made it seem different, or was our quote not specific enough, or?
I think our, the scope of service was very complete, comprehensive. So I'm not sure why, again, the bid came in the way it did.
Okay.
But, yeah, why his quote came in the way it did, but.
So, inasmuch as the scope of service may have been perhaps overly general, we're not really sure what they're seeing in the bid. I'm sure a local company might see more and understand more of what's in there, but I'm wondering if at some point the scope of that bid needs to be looked at and make sure that it's consistent in giving you the answers that you want.
The scope actually came to the commission as well.
Yeah, right.
Yes.
Yeah, and I'm not sure quite how they would see that, and not, it's just a big question mark that why they're so far apart. And obviously they're reading it differently, or maybe they, I don't know why.
Maybe they're just greedy.
Yeah, maybe they're just greedy.
Well, I think there's benefits by picking a local company who's familiar with the Hawaii market. And Mr. Dubai was the lowest bid significantly. So I feel comfortable with the information we have that I would go to Scott Ryan as the provider. And when appropriate, I can make that recommendation.
I'm on the education committee with him. That's how I kind of know him. And I've taken some classes from him. But I can make a fair and objective vote. And I do second that too, if that's a motion.
So do we need a motion to approve?
Yes.
Yes. I'm going to move to approve the broker pre-licensed curriculum based on the Scott Allen Bly quote.
It's been moved by Commissioner Emery, seconded by Commissioner Abe to approve the course taught by Scott Allen Bly. Commissioners, all those in favor say aye. Aye. Any opposed? Any abstentions? Not hearing or seeing any, motion passes. Thank you. Congratulations. Next items, I'm gonna again, this is for C2. If you recall, I'm gonna just group them all together. We had changed the reporting of the examination from a monthly basis to a quarterly basis to help staff out, since they're all overworked and underpaid. And you have the results in front of you under A, 4C2A, 4C2B, 4C2C. You have the pass-fail rates, how each school is doing. Anyone have any questions for staff on the results of the examinations?
I would just like to thank you for putting this together. It's really helpful for us to kind of keep an eye on what schools are doing, what they should be doing.
I mean, the good thing is the warnings, the major warnings is low, and, people are being more honest while they take the test. Nobody's sneaking answers in, and that's what they do. So thank you, staff. If commissioners have nothing else, we'll move right along. Thank you, staff. Item number 5, you have a list in front of you. You've had an opportunity to review of approved applications dated October 24, 2025. If you have any questions, concerns, issues with any of the names on that list, if not, I do need a motion.
I move to approve the applications for real estate for the real estate licensing.
Okay, thank you. It's been moved by Commissioner Abe, seconded by Commissioner Acosta to approve the approved application list dated October 24, 2025. Commissioners, all those in favor, say aye. Aye. Any opposed? Any abstentions? Not seeing or hearing any, motion passes. Congratulations, new licensee. Somebody's pressed for time. Item number 6 on the agenda, licensing applications. Are any of the applicants in the audience today? I do not believe anybody has signed up to speak. But let's start off with item 6A, Thomas Benjamin Brown. Thomas Benjamin Brown, he is applying for his salesperson's license. Staff did go through his application and pointed out some of the items that you also reviewed and picked up upon. Anybody have any questions on Mr. Thomas Benjamin Brown? We had some things in Arizona and Pennsylvania, I think, that showed up. As far as I can see, all of those issues have been corrected. Or staff verified that Mr. Brown's issues are. Commissioner Acosta.
Do we know how long he's lived in Hawaii?
Doesn't say. Things have changed since 21. To get that answer, Coach Acosta, to make a decision. Anyone have any other concerns on Mr. Thomas Benjamin Brown? Have a motion on his license application?
I move to approve the license for Thomas Benjamin Brown.
It's been moved by Commissioner Emery, seconded by Commissioner Kyono to approve the salesperson license for Thomas Benjamin Brown. Commissioners, all those in favor say aye. Aye. Any opposed? Any abstentions? Not seeing or hearing any, motion passes. Congratulations, Mr. Brown. 6B, we have an application here for a Jeremy Dale Seamaster, and this is for his broker's license. Broker's license. Had an opportunity to review his application. Staff has highlighted his so-called points, and also this gentleman seems to have been, this is out of state, I believe it was in Colorado, if I'm not mistaken. But according to staff, all of his fines and issues have been paid off and satisfied. Staff, I mean, commissioners have any questions? He is not present, but.
Did you resubmit the application correcting the errors?
What was the question? I'm sorry.
Did he resubmit the application correcting the errors where he had not, provided information regarding these prior convictions?
That's a question for staff. Staff, did you hear the question?
We just asked for an explanation as to why.
We have the ability to send it back to him and tell him to resubmit it
We can.
based on all the information. I don't like approving applications that aren't, as real estate agents, we have an obligation to do what the obligations are. I'd prefer we send it back to him and ask him to reapply with the corrected application person.
What is the previous commission ruling talked about in his submittal?
That was his restoration application.
But was that related to the same underlying issues? Then why is this coming up again? Because the new application was, I see what you're saying. So had he disclosed it correctly on the new application, we would just be doing the same thing we did before and allowing him to keep his license. Thank you.
I need clarification. Oh, I'm sorry. So he turned it in, it needed to be corrected. He corrected it on the second application, he didn't make the disclosures, or?
Well, no, on this application, we don't usually ask for a corrected one, we just ask for an explanation as to why they answered no. But if you wish to have him submit a new one, answering yes, we can do so. But that's what you do.
That's what you're talking about, right, Commissioner?
That's what I'm talking about. I don't like intentional or unintentional errors. The application should be accurate and correct when submitted, so I'd prefer to, me personally, I'd prefer to send it back, to have him send it a corrected application disclosing all the facts accurately.
I mean, was that a motion?
Well, I wasn't making a motion, I was open for discussion, but I don't mind making the motion, but
I had a question, can I?
Yeah, ask the question
What-
first.
Can you
before-
describe what felony menacing real simulated weapon is? Or what does that mean?
Question is, what is?
Can we take this under advisement?
Yeah, maybe we better just.
We want to discuss this in executive.
Okay.
Since he's not here, okay. So can I have a motion to take this under advisement?
So moved.
It's been moved by Chair Yamane, seconded by Commissioner Acosta to take this matter under advisement. Commissioners, all those in favor, say aye. Aye. Any opposed, any abstentions, not hearing or seeing any? This matter is now moved to be taken in executive session under advisement. Going over 6C. Alicia Borja. I hope I'm saying her name correctly. This is for a salesperson's license request to remove the conditions. So she has a conditional salesperson's license that was granted on February of 2019 due to some IRS issues. She provided some information and is now asking that the condition portion of her license be removed. And you have the documents that she supplied. Do you have any questions or concerns for staff? She is not here. And according to staff,
This was the previous, when she first came before the commission, this is the previous item.
Nobody staff recently looked at this? Or-
No.
They did?
This is Kristen's. Yeah,
Oh, okay.
Kristen.
So, commissioners have any questions? I'm sorry.
To approve the request to remove conditions.
Okay. Can I have a second? It's been moved by Commissioner Love, seconded by Commissioner Kiono to remove the conditions as she requested. Commissioners, all those in favor say aye. Aye. Any opposed? Any abstentions? Not seeing or hearing any, motion passes. Congratulations, Ms. Borja. Actually, we are on item number 7, Chapter 91, recess. Before we go into exec session, so. Mr. Minkin is here in regards to the Chapter 91 items. However, oh, sorry.
Okay, we're good.
Okay, welcome back, everybody. We're back in open session. We have 3 remaining items that we need to address. If you go back on the agenda, one item is item 4A1.
I would like to make a motion. I move to approve the issuance of a non-binding interpretation of HRS 467-1, 467-2, subsection 1, and 467-, yeah, just those two, as follows. With respect to scenario 1, the entity may have acted as a real estate broker within the purview of HRS Chapter 467 if the actions were done for the purpose or as a means of evading the licensing requirements of Chapter 467. And with respect to scenario 2, based solely on the facts provided, it appears entity did act or assumed to act as a real estate broker within the purview of HRS Chapter 467. Specific facts may change the conclusions reached in that non-binding interpretation as applied, to any other factual situations.
Second.
It's been moved by Commissioner Love and seconded by Commissioner Emery to
Issue the non-binding.
issue the non-binding interpretation on those 2 scenarios as stated by Commissioner Love. Commissioners, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Not hearing or seeing any, motion passes. Thank you. And moving on to the other outstanding item, which is 4B4, owner occupant shoe request for exemption of owner occupant requirement.
I move to approve the issuance of an informal non-binding interpretation of section 514A-107B or 514B-98.5B. That based solely on the facts presented in this case, the owner occupant requirements of the statutes are satisfied with respect to Ms. Chu and this unit, as long as the buyer does not sell, lease, or rent the condominium unit for 365 days after the acquisition of the condominium unit.
Second.
It's been moved by Commissioner Love and seconded by Commissioner Abe to approve the request with the conditions as stated per the motion made by Commissioner Love. Commissioners, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Not hearing or seeing any, motion passes. One more item, this is now item 6E, which is a broker's license request for a Jeremy Seamster.
I'd like to make a motion. I move to approve the broker application for Jeremy Dale Seamster, subject to the applicant submitting a new application that includes all of the disclosures that are required to the staff within 30 days.
Second.
It's been moved by Commissioner Emery to approve his application with the corrections and modifications as noted. Seconded by Commissioner Abe. Commissioners, all those in favor say aye. Aye. Any opposed? Any abstentions? Not hearing or seeing any, motion passes. Thank you very much. Agenda item number 8. Our next meeting is scheduled for Friday, November 21st at 9 a.m. in this very room. Time now is 11:32, and this meeting is adjourned. Thank you.